he was not aware, that he did not have knowledge that the gun was loaded, and then the judge also refused to instruct the jury to consider whether or not the gun was loaded. Okay, and as a result, he was convicted. The trial judge's view reflected in those jury instructions and in those evidentiary rulings was that knowledge simply wasn't an element of relevant consideration, an element that the prosecution needed to prove beyond a reasonable doubt, and so any evidence would have been inadmissible, irrelevant, superfluous to the issues in the case. And he's obviously convicted because he, in fact, there's not much doubt he was in possession of a loaded firearm in a public place. The prosecution kind of has him dead to rights, okay? So let's begin where it's often, if not always, useful to begin our consideration of a situation like this when the issue goes up on appeal. What does the statute say? What does the statute say that might give us some insight into the elements of this offense? Okay? How about Ms. Scharf? Ms. Scharf, what is the statute?
It says that anyone who has a loaded firearm in a public place or on a public street is guilty of misdemeanor.
Every person who carries a loaded firearm on his or her person or in a vehicle, we don't have to worry about that, while in any public place or on any public street is guilty of a misdemeanor. Okay? Does that language seem to require knowledge? As you read that language, pure textual approach to this statute interpreting.
Yeah, I feel like it does, yeah.
It does. Where in that text do you find language that would indicate a requirement that the prosecution show as an element of the crime?
Oh, no, I mean, I feel like it's implied in it. That
It's implied.
they
And what would a textualist say about an argument that something is implied?
wouldn't-
I'm sorry?
it probably wouldn't.
They probably wouldn't like that very much, okay? The idea here is when we look at, if we're going to take a pure textualist approach, we're going to ask, is there something in the language of the statute that tells us that X, whatever it is here, it's knowledge or at least some other kind of mental state, is required? And the language here, what does it actually say is required?
It doesn't say that knowledge is required.
It says if you're carrying it on a public street or in a public place, on your person or in a vehicle, you're guilty, period, right? So that's the prosecution's argument, is like, we search high, we search low, we search far, we search wide, and nowhere can we see any requirement imposed by the legislature that the prosecution bear the burden of showing knowledge, right? If you're carrying a loaded weapon, you are guilty, right? So you better know. It's Harper.
But that seems to be a problem because that sounds like violating a broken taillight law. There's no way that you can violate it without really knowing it.
There's no way you...
Sorry, that was a horrible wording on my part, but
There's no way you can violate it without knowing it?
well, there's no way to avoid
I
violating.
love that example.
No,
I love that example. Why do I love that example? Because how many of you have ever had a broken taillight and the first time you knew about it was when the police officer pulled you over and said, hey, you're driving with a broken taillight? So it is exactly the opposite of true, that you cannot violate that statute.
yeah, I meant to say there's no way to avoid violating it because you wouldn't have a way of knowing that you were violating it otherwise.
Why? Well, is that true? That may also not be true. How might you know? I mean,
Sure.
I don't think there's absolutes in this, is what I'm saying. How might you know?
You turn on your car and then walk around. So
Okay, that's one possibility. Or, good.
Well, like the court was saying here, with due diligence and, with a issue of this type, a loaded gun is very dangerous. Tail lights are important for safety. With diligence, you're going to do an inspection, you're going to check your gun, you're going to check your tail lights. And
You
that's
check
what
your
we-
taillights, and how might you go about checking your taillights?
Well, when my taillight's about to go out, it flashes real quick. I think a lot of cars do that.
Okay, and what would you do if you are suspect?
You go back there and you change it.
Or if you're totally incompetent in things like that, as I am,
You can take it to a mechanic.
you take it to the shop, right? Maybe you take your car to the shop for some other problem, and your mechanic tells you, by the way, you have a broken taillight. There's all sorts of ways you can. But the point is, the legislature might not care. The legislature might say, you know what? Cry me a river that you can't, quote unquote, know that you had a broken taillight or that your gun was loaded. Okay? We think for public safety purposes, it's so important that we're going to hold you to a standard that you better know. And if you violate it, if you do the thing that we say is a problem, we're going to hold you culpable. The issue in this case is the statute doesn't seem to require it. So what, Ms. Scharf, does Dillard say in response to that? What's Dillard's next argument? Once we've established, hey, statute didn't impose a knowledge requirement, what does Dillard then say?
I'm not sure, I just know that they said that it's harmful enough to society that they don't care.
But Dillard's not going to take that line down, right, Ms. Clements?
He says that the court violated its due process rights to present defense.
Or that the legislature did.
Yeah.
That if that's what the statute means, if that's how we're going to interpret the statute, that it violates due process, his right to present a defense, because that ought to be an issue the prosecution should have to prove as a matter of fundamental due process fairness. And the basis for that is what he calls the basic principle of common law, that to constitute a crime, there must be a union of act and wrongful intent. In other words, at the common law of criminal law, the act alone, without at least some mens rea, that is strict liability, is almost never enough. The act alone, without some mens rea, whether it be knowledge or some other mens rea, was almost never enough. And he says the constitutional concept of due process requires that it not be enough, that the prosecution prove more. So what, Ms. Clements, does the appellate court say to that argument?
Didn't they just argue that, like, the basic thing was for public safety purposes?
A little louder.
For public safety purposes, it doesn't matter, like, his knowledge of it.
What did you say? You said public safety offenses.
So it's like a strict liability, issue, so his knowledge doesn't matter for public safety purposes, like, he's guilty regardless.
You can use any of these terms you like. I don't really care. They mean the same thing. Whatever you call it, this class of offenses is not three different classes. It's just three different names for the same thing. Okay? Public welfare offenses, public safety offenses, regulatory offenses. With this group of crimes, as distinct from the other category we'll talk about in a minute, the common law rule they almost always, and there were some exceptions to this rule we'll get to later, okay, but I'm going to put it up as if it's an absolute rule just for simplicity's sake for now. The common law rule or tradition of no strict liability does not apply. Okay? Strict liability is okay, in other words. So that means it's important for us to be able to do what? If we're going to say that a traditional rule is that there's no strict liability won't apply, what's going to be critical for us?
This public safety is in jeopardy. Because
No, I mean what's going to be critical for us in understanding this area of the law.
Well, I was just say defining Like, which?
Exactly. We're gonna have to know what defines this class, since we're saying it has such a sharp break. There's such a distinction between these regulatory offenses and what we'll call traditional common law crimes. We better know what defines this class, because courts are gonna have to apply that rule and say, this is a regulatory offense over here, this is a traditional common law offense over here, this one you can have strict liability as a matter of due process, and this one you can't. Big difference. Okay? So what does the court say? We'll start our consideration here and continue it in Wool. Are some of the defining characteristics of regulatory offenses? Give me one.
It has to be known to common law. Is that what-
I'm sorry?
But it has to be known to common law.
And that is part of the regulatory offenses?
Be a part of the offense that constitute, impinge upon public safety perhaps.
Those are two different things. Which one are you gonna ride?
The common law or the public safety?
Will you tell me?
For this, let's do public safety.
Okay, and so what's your defining characteristic? If we were gonna make a list of things we're gonna look for in whether something is a regulatory offense or a public welfare offense, right? Because we want factors in a test. Give me one.
Deals with neglect.
I'm sorry?
Deals with neglect, where
Give me more.
well, this
What
line
do you mean
says,
deals with neglect?
is in the nature of neglect, the law requires care or inaction or imposes a duty,
And why? Why would the legislature have done that?
because just the acts, like not taking that care is dangerous to public safety.
Good. Number one factor, the legislative intent shows concern with public harm or safety. So that becomes, that's the primary reason. The legislature's primary concern was the harm that certain acts might do, that they're dangerous. As opposed to what on the other side might be the primary purpose of a criminal statute. Kind of already talked about this the first week of class.
General deterrence, like so the next.
I'm sorry?
Like general deterrence, so that the next time you would check to see if the gun was loaded before you left his house.
Put all of the purposes together. What's the primary concern with most criminal statutes, or the primary reason? Punishment, right? With traditional common law offenses, TCLO, traditional common law offenses, the primary purpose is to punish, as opposed to regulating for the sake of safety. Now there's some overlap here, right? We might use punishment on both, and we use punishment here because we want to give disincentives to people to engage in the dangerous conduct, or to have incentives to take care and to check their taillights, or to check whether their guns are loaded, right? So it's a device, but the primary focus, if it's a regulatory offense, is to regulate, to prevent danger. To prevent danger, right? So if punishment is not the primary cause or concern, what else would be true of public welfare offenses that sort of follows from that?
Don't they usually, instead of imprisonment, lead to just fines or penalties or something?
Or if it does have imprisonment,
It's not, I mean, it's not long term.
it's what?
It's not long term, a long term
Good.
sentence, yeah.
Less severe punishments. And we'll see this most prominently in Wolf. One of the hallmarks of regulatory offenses is fines or very short terms of imprisonment. Right? And so as we build this list, we'll see that the courts say that in these circumstances where these attributes are present, the thing the legislature determined there was a danger it was trying to prevent. They didn't impose severe punishments, but they did want to have some mechanism to make the regulation enforceable and with some bite. Then it doesn't violate due process under these circumstances to define these crimes and to have these crimes in the code and to then allow conviction without fault, that is, without a mens rea. Okay? What about this law? Is this law one of those that where it's acceptable, that is not a violation of due process, for the legislature to impose strict liability? I.e., is it a regulatory offense?
Yes,
Okay, tell me why.
because the goal of the law is to protect the public safety, and so whether or not he had any knowledge because of I think it was like a 1922 Supreme Court case, like knowledge, it doesn't matter that it's not explicitly in the statute. Knowledge isn't an excuse, that doesn't have to be an element of it. He violated by just having it, and so that doesn't matter that he didn't know.
And explain to me the reason, if you were the prosecution arguing this case before the appellate court, how would you argue that this really is a statute designed to and well fitted to avoid a public danger? Defining the public danger and how this fits into that category of crimes.
Yeah, so the same way that they did that, the fact that he did not know is probably more dangerous than if he had known that the gun was loaded and in there, because without knowing, he was riding around on his bike. It could have fired. When he put it down, he could have shot the police officer. So the not knowing is not good enough. You need to take the care. You have the duty to the rest of society to protect
So the
them.
argument would be, look, whatever you think of gun rights, of the Second Amendment, of the right to own and possess a firearm, that the legislature can prescribe reasonable rules about what makes a gun, to make sure a gun is being used and possessed safely. And the very fact of not knowing whether the gun you possess is loaded makes it dangerous. That's a legislative judgment. And here, the punishment is not all that severe, but the idea is we want to give you some reason to acquire or to have the knowledge that this guy lacked. And it's not going to be an excuse that you lacked it, because that is what creates the danger in the first place. Okay? Okay, questions about that? Again, we're starting to build this rule, but we'll continue to build it in Wolf and sort of get our distinction between traditional common law and regulatory offenses.
Are you asking questions about the case?
Yeah, questions about this case?
Yeah, I just thought it was weird when the cop said that the weapon had no safety latch. The chances of it going off, if it were dropped from the bicycle, were about 75%.
Yeah.
How would you be able to prove that?
Let's say you're a prosecutor and you want to be able to make that point to the appellate court or at trial. Let's say you want to make that point at trial. What would you do?
If I was a prosecutor, I'd make a point against to prosecute the defendant.
Yeah. How would, I mean, let's play prosecutor. How would you go about trying to prove that? I beg your... Get an expert. Exactly. You get an expert who says rifles or guns without safeties have this propensity to have this result under these conditions. Maybe you have that expert to conduct a test. Have a gun dropped with presumably blanks, dropped 100 times or 500 times. And let's see how often the damn thing goes off. Right? That's what good lawyers do. They get the evidence they need through experts, through people with experience. Maybe there was somebody who testified in the legislative hearing who has done research on this question. You bring them in, right? That's how you build your case at trial. Now, whether that was done, whether that evidence was introduced at trial, is lost to the ages now. But that's how I would do it. Okay? Other questions? Okay, I want you to look on page 206. Note 4, defining strict liability. And how many of you felt totally comfortable and like it was the easiest thing in the world to understand the distinction discussed in that note between pure and impure strict liability? I see 0 hands. So let's talk about it, okay? Take your best shot. Even if you didn't feel like you had the most perfect grasp of it, how would you describe if somebody asked you, let's say I gave you a multiple choice question on an exam, and the question was, what is the most accurate definition of pure strict liability? What answer would you be looking for and hope you saw so you can say, it's B, that's it? It's a long one.
One is strictly liable for doing an activity that is so dangerous that nothing could make it safer.
And if you chose that answer, unfortunately, that would be 1 point you would not get. Okay? Because that is just a general definition of strict liability. It doesn't distinguish between pure and impure on the grounds that the authors talk about.
You wanted for pure?
Yeah, for pure.
Liability without any culpable mental state with respect to any objective element.
Give me a different word than any and we'll be right on it. I mean, because I'm not sure exactly what you mean by any.
Sure, without respect to, put it that way, without respect to any objective element.
Not quite. Why do I not like any there? What was the ambiguity in any?
Because of those elements?
It has to be all the elements with respect to every element of the offense. Pure strict liability means, whoa, that is not cool. Pure is the statute lacks any mens rea with respect to all elements of the offense. And we'll talk about an example of this in a minute. Okay? That is pure. Right? Across the entire scope, every term, every clause, every subsection of the statute, which may have multiple elements, none of them have a mens rea requirement. The statute is completely one of strict liability.
So for impure, would that mean that it does, there may be mens rea for some elements, but there's no mens rea for at least one element?
That's exactly right. Impure is strict liability applies to at least one element, but not all. Because if it was all, it would be pure. Okay? Now, that's all well and good. Let's give a concrete example. And the one on page 206 is great. It's a really good example you can get wrap your heads around. Richter.
Sorry, can I ask a question first? That also between substantive.
I don't want to talk about substantive.
Okay,
Okay?
so don't.
You do not need to know substantive and formal strict liability.
Okay.
Period.
Okay.
Right? Because in my view, that distinction is much more confusing than it is helpful, and it really is a distinction created only by a bunch of scholars to critique strict liability. There's nothing in the law that actually distinguishes between substantive and formal. Okay, so don't worry about it. If you really care about that, if you really want to dig deeper, come see me in my office and we'll have a nice long chat about it. But you do not need to know it. I think it is completely superfluous to any understanding of criminal law. That's my own view, and since I'm grading your exams, run with it. Run with it, take it, hoard it as a precious gift. Okay? Just worry about pure and impure. Okay? So the example given on 206 is the statute makes it a crime to possess a controlled substance that contains a hallucinogen. So I forgot my item. There we go. Hallucinogen. Okay? What would be if the remember, this is all about what the statute requires the prosecution to prove beyond a reasonable doubt. What would make that a statute of pure strict liability? You're a prosecutor and you're saying, what do I not need to prove? Mr. Williams.
If you have it, then you pay the fine or go to jail.
And the prosecution does not need to show knowledge or intent or recklessness, etc., whatever it is, does not need to show it as to what are the elements that the prosecution is free and clear on when it comes to mental state.
Right. They don't have to know that they had it.
Right.
They don't have to know
possession.
They don't have to know that it was controlled.
Good.
And they don't have to know that it had a hallucinogen.
Any of those. That would be pure strict liability. Right? Because there's different elements here. Did I know I have it? Right? Or did somebody plant it on me? Doesn't matter if it's strict liability as to possession. Did I know what it was? A controlled substance. Maybe that's where the statute might say it's a crime to knowingly possess or to possess a controlled substance that the defendant knows contained a hallucinogen. Right? So that none of those. It would be impure if it was only as to one. I knew I possessed. Right? That's strict liability, but maybe there's an intent requirement as to the other parts. Right? There's an intent or a knowledge requirement as to the other parts. That would be impure. Okay? And it can be any combination, as long as there's at least a mens rea as to one element or two, then it's impure. Critics of strict liability, those who think it should be reserved for very rare circumstances, or some people oppose it in all circumstances, think that even impure strict liability is a problem. That there should be a mens rea element as to every element of every crime that the prosecution tries to prove. Now, legislatures differ from that, and your job will be twofold. Interpret the statutes that are put before you to see whether they impose strict liability, pure or impure, and decide whether, if they do impose strict liability, it was acceptable for the legislature to do that, or whether it violated some constitutional provision like due process. And part of that is this distinction.
Okay, I just want to clarify, when prosecutors are dealing with impure strict liability, does that, assuming that because at least one element does not have mens rea, but like another element does, do they have to prove the element that does have mens rea?
Yeah, they have to prove whatever elements, however that element is defined. Let's say that a statute says a defendant is guilty of possession of a controlled substance. If they possess a controlled substance, they know contains a hallucinogen. Okay? Then the prosecution has to prove possession. They have to prove what they possessed was a controlled substance and that they knew it had a hallucinogen. And the jury should be told, ladies and gentlemen, jury, convict the defendant. You must find that she possessed a controlled substance and that the prosecution proved beyond a reasonable doubt that she knew that the controlled substance contained a hallucinogen. Okay? And we see that? That's what you're going to be looking for. Sometimes it'll be in the language, if you're a textualist, and sometimes courts infer things based on legislative history, or who knows. But that's when the game gets even more annoying or fun, depending on your perspective, when the statute isn't entirely clear or it's somewhat difficult to understand. Okay, questions about this before we move on to Wolf? Yeah,
How does knowledge of jurisdiction play into this?
I beg your pardon?
How does knowledge of jurisdiction play into this? See,
Knowledge of jurisdiction?
moving from one county to the next where different statutes apply,
Well, moving from one county to the next is probably not an issue.
or state lines.
Well, then you're getting to if Congress passes a law that, let's say, criminalizes transportation of controlled substances across state lines, that statute may say, you must know that you're crossing state lines, or it might not. And Congress has done both things in different statutes. They have sometimes imposed a mens rea, and they have sometimes not. So you'll have to look for that, right, when Congress decides that. Now, state law, when you cross county lines, I mean, the state of Kentucky criminalizes, let's say, possession of controlled substances. They don't care whether you cross from Jefferson into Oldham. They're just not really much concerned about that.
Okay, so for this one, the only thing, if it was pure, the only thing that would have to be proven is that they possessed it.
Well, and that it was in fact a controlled
A
substance
controlled
that had a
substance.
hallucinogen.
So,
Yeah,
because I was
please.
looking at because they give you these different scenarios and the different people involved. So, like somebody who just found the pill on the ground, they would sort of argue over whether or not that was actually possession.
Well, good luck to them. If you're holding it in your hand that you picked it
Okay.
up off the ground,
Okay.
you possessed it.
So, would everybody in the scenario they gave technically be guilty?
It depends. I mean, remember, you have to distinguish between pure and impure strict liability. If on impure, there might be a knowledge requirement that would protect some of them. If it was pure strict liability, then yes, they'd all be guilty. And you don't. And what do you think of that? You're allowed to have opinions. Don't worry.
I mean, it seems harsh, but
It seems harsh.
yeah.
And if you were in the legislature, you might write the law differently. Now, some legislatures, on some crimes, they do it this way, but then, and it's sort of a trick, and what it does is relieve the prosecution of a burden of proof beyond a reasonable doubt, because they switch it over into a defense. And they put the burden on the defense to say, well, I didn't have knowledge. And there's a case in the notes, I think it's on the very next page, maybe it's a little later, maybe, it starts on 212, I think. Yeah, 212. In Atkins, the case discussed on 212, the Florida Supreme Court said that's fine. The legislature can, without violating due process, make lack of knowledge a defense. So just because there's strict liability, because strict liability refers to what the prosecution has to prove beyond a reasonable doubt, doesn't necessarily mean that knowledge becomes 100% irrelevant if the legislature then turns around and says, but we'll give the defense the chance to show lack of knowledge. What it does is it flips the script. And the defendants argue that that is effectively relieving the prosecution of part of the burden of proof it should have to bear as a matter of fundamental due process. So you want to look for that too. Some statutes may make the reverse, the lack of knowledge or the lack of intent, a defense once the prosecution, let's say the prosecution shows all of these things, forget knowledge, that's not in there, shows that the person was in possession and that it was a controlled substance and that it contained a hallucinogen, the burden then shifts to the defendant to show, oh, wait a minute, I didn't know that I was in possession, or I didn't know it was a controlled substance, etc. Right? And some courts have upheld that, and some courts haven't.
So at that point, it's just up to the people who are on the jury to decide, do we want to accept this or do we not?
Well, it's always up to the jury to decide on the facts. Do I believe the defendant's defense, that it was innocent on their part when it comes to knowledge, that they just picked it up off the street because it had a pretty color and I was curious what it was, right? I had no idea, right? Or one of the examples in that hypo is a pickpocket who steals the wallet that contains the pill. Okay, you've just confessed to being a pickpocket. Good luck with that. But at least you weren't in possession, knowingly in possession of a controlled substance, right? So that was a defense. You might be able to convince the jury, right? And that might plausibly work, right? Because you're confessing to something, and who would do that, right?
So if I'm a defense attorney, I would want to show you could do this too, and if this were you, would you want to be convicted of something?
You could. Again, we're assuming it's relevant, because we're assuming we're in a jurisdiction that makes it relevant either as an element of the statute or as a statutory defense. But either way, yeah, you're going to try to convince the jury that there's a plausible narrative to the lack of knowledge that you're either trying to prove or show that the prosecution failed to disprove, depending on which is required.
Pleasure.
Okay? Let's talk about Wolf. With what was our friend Wolf charged? Miss Jarnigan, is it? No, Miss... I'm not going to be able to read that in a million years. You're going to have to help me there. Rangaswamy. Go ahead.
He was charged with selling migratory bird herds that was in violation of the Migratory Bird Treaty Act. So he sold essentially.
And what was involved here? What was he trying to sell that violated this treaty act?
A necklace made of feathers using a red-tailed hawk and a great horned owl.
Did I hear you say the word hawk? Hawk is the word today. And he did. And how do we know Wolf was not the smartest criminal in the neighborhood?
Because he sold it to an agent who worked for the United States Fish and Wildlife Service.
Right. Anytime your client is one who gets caught by an undercover agent, it's time to plea bargain. I mean, these are generalizations. There can be exceptions, but in this case, not very smart. Okay. And since both of these birds, the hawk and the owl, the great horned owl, are protected birds under the act, selling parts of them is problematic if you're a wolf. So this is the charge. And what does Wolf's attorney do at trial?
Wolf's attorney pretty much says that he had no intent and had no knowledge that this was even this act.
And what does that mean? He had no intent and knowledge, and
So he said that this violates his due process rights, given the fact that, also this act is not necessarily well known under the common law.
so he says what is the exact content of the argument to dismiss here?
He says it does not require guilty knowledge.
It does not require guilty knowledge.
And therefore, imposition of a felony conviction would be a violation of due
Good.
process.
Because they want to impose, the government wants to convict me of a felony. And that violates due process. And therefore you have to dismiss this charge under 797B2. Okay? And what does the district court do? Sort of an interesting split the baby in half kind of resolution. What does the district court do?
The district court, they dismiss the indictment.
But
they imposed a fine and said he had to go to prison for 2 years.
But they indicted Wolf on a felony charge.
Didn't they say if he was convicted, they would convict him of misdemeanor?
Right. The district court says, okay, fine. Fine, Wolf. Your argument is this is not a felony. It violates due process to convict of the felony. So instead, if you're convicted of the substantive crime, we will convert it into a misdemeanor. This is very creative and pretty unusual. Right? Normally, I'm sure Wolf's lawyer thought if I can get the court to agree with me that it violates due process, they'll just dismiss the indictment, period, and we'll all go home. But that's not what the court did. The court said, okay, I agree with your argument to impose the felony sentence, the much more serious felony sentence with the more serious consequences, would violate due process. So we'll go through, see what the jury does, and then I will only impose the misdemeanor sanctions, because that is less serious and would not violate due process, okay? So in examining this act, Ms. Ramaswamy, in examining this act, what does the district court say, the Court of Appeals say about the nature of this act?
They were saying that in this case, necessarily there was a larger detriment in the punishment than there was for the actual crime he committed.
Not what I'm referring to, though that's true. What the court gives certain attributes of this statute, observations about this statute. What does it say first about whether it imposes or requires a mens rea?
Oh, it says the statute omits mention of intent, but the elimination of this element is not actually violated of the due process clause.
Perhaps. We'll get to that in a minute. Does not require intent. Right? So the prosecution's right on that in terms of what the statute requires. What the implications of that for due process are is another question, but the statute does not require, as the court puts it, proof of scienter or proof of intent or knowledge or anything else. You sell migratory bird parts or attempt to do so, you have violated the statute on its own terms. Okay? How does the court classify this statute in terms of what kind of statute it is?
They said they differentiated from common law
Good.
statutes.
Not known to common law. Give me an example of what you would think was a traditional common law offense before we had the age of statutes replace the common law.
Battery.
Battery. Or murder, right? And then these were common law offenses that courts could try, even if there wasn't a statute that actually defined murder, which creates, as we'll see, a whole lot of interesting need to develop the law, ambiguity in the law from case to case, because there's no actual statute courts are interpreting. And then in the 19th century, the beginning of the age of statutes come along, and legislatures start to codify in statutes the terms of these common law offenses as they had developed, right? So one thing that we're going to look for is the statute that we're dealing with in any given case, is it the codification of a traditional common law offense, or is it one that was not known to the common law? What do you think criminalization of the sale of migratory bird parts, which side of the line is that on?
Modification.
Definitely not known to the common law, right? This is a function of, a creature of the age of statutes, right? We weren't just bringing a common law offense under the statutory umbrella. This is creating something brand new, right? So, and if the statute is not known to the common law, that's a factor in it being a regulatory offense, being a public safety or public welfare offense, okay? And what else does the court say about this particular statute that's relevant to the consideration? Mr. Wiseman, right?
Yeah. Well, they, from this other case they talk about, they have it's more like a test, but they also talk about the reputation, like what if convicted at the time would it besmirch this person's reputation.
Damage to reputation, and the other dimension of that is serious penalty, right? When you're convicted of a felony, the two things that go along with that is you get a longer sentence, harsher punishment, and it affects your reputation. So the court says one other aspect, or one other dimension of this statute is the severe punishment, okay? Severe harm to reputation. So here we have a statute and a conviction that sort of, there's elements that point in both directions. It's not a common law offense, but the punishment is severe. And that raises the question, is it okay for the legislature to impose strict liability for this statute?
No, I was just gonna say, so basically the court's saying that the two elements aren't matching up like they should be for one or the other.
Move that again?
So the question here is which one is the statute actually going with? The regulatory offense or the
And
traditional
how does
common
the
law?
court balance these factors? How does the court balance them? Yeah.
Doesn't the court seem like with Congress, like they have to require the prosecution to like prove that the defendant acted in like some like incident, like some sinister act, but it's not necessarily like a common law, like in this kind of situation. So therefore, like, well, like wasn't found like guilty since the court found it was guilty.
The court says exactly right. The court says, look, the fact that it's not a traditional common law offense doesn't give the legislature, here Congress, carte blanche to just completely depart from the requirement of some sort of mens rea, right? When you're trying to impose a harsh punishment and affect their reputation, that is problematic, and it violates Wolf's due process rights. Okay? Now another court dealing with this exact same statute, this decision was by the Sixth Circuit, I believe it was the Third Circuit, decided the exact opposite. Decided that strict liability was perfectly fine under the Migratory Bird Treaty Act. So sometimes you will get courts who see the same question, deciding the same question, come out on different sides, and in this case it would have to be the Supreme Court of the United States that would have to resolve the question. Right? But this is not the kind of issue that is necessarily one-sided absolute, because you're balancing things. You're balancing all of these considerations. How much punishment was there? Is there harm to reputation? Was the legislative intent clear that it was meant to be to avoid danger? Was it a rule known to the common law? Those are the factors you're going to look for. Okay? Yeah.
So could you say that according to this court, you have to have a mens rea to be convicted of a felony?
I think that's a little bit of a blanket statement. One could imagine, I guess, that the Sixth Circuit in another case might find another felony to be substantially less serious, even though the label felony is applied. But I think that's a good starting point. I wish, maybe this is your first exposure to it, maybe you've seen it in your other classes before, where you don't get a clear, straight, easy answer. The last thing I want to do is say there's some absolute rule that felonies automatically go on one side of the line. You have to look at all of these factors.
Could we add to that, then make a better definition, if the crime is not known to the common law? Like, it seems like what makes this not okay is that it's not something people would have that much knowledge of, whereas carrying a loaded weapon in public, they would.
No, I don't think you can say that at all, actually. I think the point of strict liability, let's say they had made this only a misdemeanor, the fact that it was not that well known wouldn't save Wolf. And in fact, he got convicted of the misdemeanor. Right? He got convicted of the misdemeanor. So you can't just say because it's not that well known. In fact, the fact that it was not known to the common law works in favor of the government, not the defendant, because it makes it more likely to be found to be a public welfare offense where the legislature is more free to impose strict liability. Whereas you're trying to argue quite creatively that the fact that it wasn't a well-known thing should give the defendant a break, and it actually works the opposite way. And the fact that it's not well known, if it's dangerous, well known or not, if it is harmful to the public safety, if the major intent of the statute was to regulate rather than punish, which is part of the difference here in the level of punishment, then that's gonna weigh in favor of the legislature. You can't, I mean, there's this impulse, you wanna look at, be able to sort of stress one factor, and say, aha, that's gonna be my deciding one. With a test like this, you've gotta look at all the factors. Although that does not give you clear rules. Right? And if that's frustrating to you here, which it probably is, just wait till you get con law, which is all gray areas, all balancing tests, and it's the most annoying class you will ever take. I love teaching it, but trust me, from a student's perspective, you will be tearing your hair out. So just a little peek ahead. Okay? Questions? Yeah.
So just to make sure I've got this, the Aldrich test, that balancing test, the penalty is relatively small, not known to common law, conviction doesn't gravely besmirch the reputation.
Good.
Is there
The legislative intent to deal with a seeming danger or harm to the public rather than to punish for the transgression itself. And on the other side would be fulfilling all those purposes we talked about, where the primary purpose is to punish. And that fits sort of, and it has a nice sort of fit between the lower punishment and the legislative intent to regulate rather than punish. Okay? Okay. That leads us to Lambert. What did the Los Angeles Municipal Code, section 5239, say? That ended up being of kind of significant relevance to our friend Lambert. Ms.
Nair.
Nair. Ms. Nair.
It says it shall be unlawful for any convicted person to be or remain in Los Angeles for a period of time of more than 5 days without registering. And then it is required that any person having a place of abode outside the city should register if he comes into the city on fabricated or more during a 30-day period.
And so what immediate question does that statute or that ordinance raise for you? If you starting with 5239, what would you immediately want to know if a client came into your office and said, I just read about this and I'm worried? What would you want to know immediately?
If they had like prior knowledge to this?
Well, we'll worry about whether there's a knowledge element first, but in terms of even the statute applying, what would you want to know?
Whether they were convicted of
Whether they're a convicted person, because the statute only applies to convicted persons. Is there any place, Ms. Nair, you can look for whether, to determine whether your client happens to be a convicted person?
Section 52.38A says Los Angeles Municipal Code defines convicted person, any person who, after January 1st, 1921, has been or hereafter is convicted of an offense punishable as a felony in the state of California, or who has been, who is hereafter convicted of any offense in the place other than the state of California, which the offense, if committed in the state of California, would have been punishable. So, any offense outside the state of California that California would say is punishable or goes convicted.
Now let me probe this with you for a minute. Do you think, is it your impression of the criminal law from state to state to state to state that the definitions of offenses, of crimes, of what is a felony, what are the elements of felonies in each state, let's say from Kentucky, let's proceed west to Illinois, then Missouri, et cetera, we'll go all the way west to California, that the definition of each offense is exactly the same from state to state to state until we get to California? Probably not. It's one of the either virtues or annoyances of our federalist system, where we have 50 states plus a federal government, that the law is different in every state. So what might be a crime in one state might have a different element in another. It might be a felony in one state but a misdemeanor in another. So how clear, on a scale of 1 to 10, do you think it would be if you had a client who came to you and said, well, I was convicted of assault in Nebraska? Does that impose upon me the requirement that I register in Los Angeles?
No.
I asked for a scale. How clear is it from 1 to 10?
Like 5?
I think you're being really generous.
Okay.
I think it's like 2.
Okay.
Right? Because you might, if you didn't do any research, if you didn't look for the Nebraska statute, you might say, well, is the conduct as they defined it in Nebraska that constitutes assault, would that constitute a felony in California? Maybe the definition of assault in Nebraska is really loose, really lets the prosecution nail you for what in California they think is pretty minor conduct. And it would only be a misdemeanor in California, because you got to look at the definition. So it's not self-evident, at least, with respect to a lot of offenses, whether, even if you're convicted in Nebraska, whether it would constitute a felony in California. So you could really be in doubt. You as the client, or even you as an attorney advising the client, do you have to register? Do you have knowledge? Now let's presume you do have knowledge that you're in Los Angeles. It's kind of hard to miss. You're in Los Angeles. Let's say there's knowledge of that element, your presence in LA. You've been there 5 times, or you live there. But you might not have knowledge that the crime you've been convicted of does constitute a felony in California. So the knowledge element becomes pretty darn significant. If knowledge is not required, who cares what you knew about the status of your conviction elsewhere? If knowledge is required, then we all care. Everyone see that? Why the knowledge element could be really significant. Because crimes are defined so differently from state to state to state. Tell me about Lambert.
So he was arrested on suspicion of another offense and then was charged for violating the registration law.
And why was Lambert charged with violating the registration law?
Because he was converted. Because he was arrested for a crime.
How long had Lambert been
Over
in
7
Los Angeles?
For 7 years.
For 7 years, and had never been registered. And it turns out that she had been convicted of, prior to this.
Crime of forgery.
And what does California think of forgery?
Felony.
It's a felony. So she had not registered, she had been in Los Angeles, having been convicted of a crime punishable as a felony, and that seems to be that, right? And the statute or the ordinance here does not require willfulness or any mens rea in the terms. And the California courts have not read it in as an element the prosecution has to prove, okay? So Lambert tries to offer proof that she had no actual knowledge of the registration requirement. Like, I didn't know that I had to register. I didn't know I had to register. So the question is whether a registration act violates due process, whereas applied to a person had no actual knowledge of the duty to register, and no showing is made of the probability of such knowledge. And how does the court resolve this question? The U.S. Supreme Court. does the court resolve that question? Mr. Ken?
Yes, it says that knowledge or probability of such knowledge is required.
So it violates due process not to require such knowledge, or to require the prosecution to prove such knowledge. That seems like a pretty landmark and earth-shaking decision, that it violates due process to convict somebody without knowledge. So much for strict liability. So much for strict liability. That's what the Supreme Court says. It violates your due process rights to convict you without a showing by the prosecution of knowledge, presumably beyond reasonable doubt. So, if we still have strict liability statutes, what must be true about this statement?
It didn't hold up against the weight of a lot of other cases.
Well, no, the Supreme Court is the Supreme Court, and it.
I'm sorry. I mean, in terms of.
But what do we know about what must be true about this decision?
Notice of like that you have to have a due.
Not exactly. It must be that.
There's have notice and an action.
No. What do you mean by notice and an
Like
action?
you have to, like, you need to go register, and then you go register. If you don't know that you need to go register, you can't.
What is the nature of this statute? What is it? What constitutes the violation?
Failure to act.
Failure to act. The Supreme Court says one thing about this law that makes this true. It's not just true of any law. If this was true of any law, if this was the rule for pretty much any law, we'd pretty much be done with strict liability. The Supreme Court says there's something unique about this law. And the unique things are what allows us to announce this rule under these circumstances. The behavior, the court says, was wholly passive. The violation, failure to register, or an omission. So one thing we know is that when the activity, when the crime, when the violation is something that's wholly passive, that is a failure to act, the rule is bigger. The rule is tougher on the prosecution. It would violate due process to require the state not to require the state to prove such knowledge. And what else does the court say that sort of to limit this holding to this particular kind of statute? The court says something else. You gave it to me, Ms. Bacchus, is it?
Yes.
What else did you say other than the wholly passive or failure to act part?
You have to notice.
Notice when?
Before you act.
Before you act, or when does the state have to, in order to then convict you, give notice? The court is very specific about this.
Where a penalty might be imposed for mere failure to act.
They have to give you notice before prosecuting you. Before prosecuting you. So again, if it's a wholly passive kind of violation, it's not like you went and robbed a bank. Right? The state does not have to give you notice. Oh, wait a minute, you're not allowed to rob banks before it prosecutes you for, hey, robbing a bank. But if it's something where you simply fail to act, the state should give you notice that you need to act. So if two things are present, two things were present in Lambert that make it a very narrow decision. The two things are that it was a failure to act situation, the violation consisted of a failure to act, and since it was a failure to act, an omission, the state should have given people notice that they needed to act before then prosecuting them. So if you're coming to Los Angeles, there should be some sort of public notice given or specific notice, even when you come to register for your driver's license, that you're a convicted felon, you need to register with the city of Los Angeles, right? So those two things say if you're gonna prosecute somebody under these circumstances, you didn't give notice, and it was a failure to act, then you better show their knowledge of the requirement. And if you don't show their knowledge of the requirement, it's gonna violate due process if these two things are present.
So in Wolf, when they said that a felony is too strict to be strict liability, and you said that's not a blanket statement, but since this is the Supreme Court, would that rule of
Was that an omission?
notice be?
In these particular circumstances. But if you call it, is it a blanket rule? It's a blanket rule in these very unusual circumstances where you have this confluence of the law involving a passive act and the state not having given notice and then trying to impose strict liability. No knowledge. All of those things coming together, then yes, that's the rule. How blanket, it's a very small blanket. But yeah, it's a blanket rule in that sense. Lots of hands, yeah.
So kind of like timeline, like you have to get notice first, and then if you fail to act based on that notice, and then you're like in violation if they show that you had knowledge of the
Well, there's sort of a catch-22 there for the state. Obviously, there would be knowledge of the registration requirement if the person had received notice. So then presumably they'd be able to, the city would be, or the prosecutors would be able to show, hey, Lambert, or whoever the defendant is, had notice. So they have no excuse. And therefore, you're essentially, the notice requirement almost overlaps with a knowledge requirement, at least in omission cases. Okay? So that's the sequences. There has to be, maybe the notice is the police happen to pick her up for a charge, notice she hasn't registered, and give her 7 days to do so. Something like that. Then you're on notice. But before you would prosecute, you're given one shot at the apple. Or perhaps the notice could be, at the first instance at which you interact with city government upon moving there, like your license renewal, or when you pick up your California plates, right? Maybe there's notice that you're given. If you move to Los Angeles and you are convicted of a felony elsewhere, here's what you must do under California law. Okay? Yeah.
So would you say then that these kinds of cases where they require notice to be given, are those probably more likely than not going to be in regulatory cases, or cases that are where somebody violates a regulatory code rather than a common law statute? Or
In terms of what legislatures actually do, legislatures, as opposed to what's permissible, right? Because the Supreme Court holds it wasn't permissible here. And this was pretty much a common law. This was a regulatory offense. It wasn't really a common law offense, right? Failure to register. What legislatures actually do is they want to, 95% of the time, they want to look tough on crime. So they create penalties, they make it easy for the prosecution, and then they go home to their districts and tell their constituents how tough they were on crime. So that's what actually happens. And they don't really respect the distinction or care much about it between regulatory offenses and traditional common law offenses. So I think they do both things. Whether they all get upheld and applied by courts is a whole different story. Okay? Yeah.
If we were going to use this as precedent for some future case that we're doing, can we only apply this to failure for a duty to register, or anything that is a failure to act?
I would certainly try if I'm the defense lawyer. Obviously, if I'm a prosecutor, I'm going to try to say, oh, Lambert only applies to registration cases. And if I'm a defense lawyer, I'm going to say it applies to any omission case. And the court would have to decide that, right? That's a great question. That's how the law develops. The law develops if you have one case that each side might interpret either more narrowly or more broadly, the next case has to decide how broad should we interpret it and apply it to a new situation. And that's a great example of how it could go either way. And each side is going to argue it. If I'm the prosecution trying to limit it to registration cases, because I have another omission case that I don't want Lambert to apply to, I'm going to say the court's real concern there was the danger of overzealous prosecution, police abuse of power, where they have in their back pocket registration statutes. And registration statutes are used when they pick somebody up who might be unpopular or who might look suspicious or who might be a minority, etc. And then but they can't get them on anything else, so they get them on registration charges. And this statute is uniquely, these sorts of laws are uniquely subject to abuse. So that is the underlying reason the court limited registration statutes, and that's not true of others. That's the prosecution's argument. Might be persuasive to some courts. If you're the defense, you're going to say, no, the court said omissions, failures to act of all kinds are subject to this rule. So don't limit it just to registration statutes, right? How is a court going to rule on that? I have no idea, but it would make a great part of an exam hypo. And whatever side I put you on, you'd have to argue. And these cases give you the tools to argue one side or the other. So you want to be able to say, Lambert is a tool that I can use, and in some ways use on either side, but you should be thinking about every case. How would I argue this if I had to use it? And how would I distinguish it? What facts could I use to distinguish it away if it was harmful to my argument? That's what good lawyering is all about. Using the tools available to you, whether they're case precedents or whatever they are, to either support or distinguish your argument. Okay? All right, let me just take a couple minutes to talk very, very briefly about your memos in general terms. Like 3 things that I've noticed that apply to a lot of you, although not all of them, the ones I've looked at so far. First, memo format. Okay? If you compare your memos, a lot of you, to the model answers on Blackboard, you will see to, from, re as the formatting. That's what you want to aim for. Now, I didn't expect you necessarily to know that or do it, but that's fine. There's no grade involved here, right? But that's what you want to do if you're asked to write a memo. If you're asked to write a client letter, then style it as a letter. Dear Ms. Smith, blah, 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 blah. But if it's a memo, you want to use to, from, re. Second, the opening, the intro paragraph. At least for me, others of your professors may differ. They want a different writing style, they want a different approach, and welcome to the law. Because you'll be writing for different partners, different bosses, different judges, who will want different things. And knowing your audience is part of good legal writing. I will always want you to take a clear position in the intro and summarize the basis for it. You may have seen that in the model answers. If you hemmed and hawed, or were ambiguous, or just introduced the issue in a neutral way, that's not what I'll be looking for. What I'll be looking for is, you have asked me for a recommendation whether to extradite Mr. Burns or seek extradition of Mr. Burns from Oregon. I recommend that we extradite Mr. Burns in order to serve the purposes of retribution and general deterrence. Right? You've told me what you're going to say, what you're going to recommend, and the basic reasons you're giving for it, right up front. My view is you will never be persuasive to your audience if you haven't told them what you're trying to persuade them of. Right? By definition, you can't be persuasive if the person who's reading it doesn't know, well, what position are they trying to persuade me? So just tell me that right up front. Third and finally, when you're dealing with counter arguments, this happens all the time. Every year, inevitably, and it's true for a lot of your memos, you tend to argue defensively. When you want to bring up, let's say you argued for extradition, and you want to bring up one of the weaker points for you, like, let's say, rehabilitation. And the way almost all of you have done it so far when you're bringing up those weaknesses or counter-arguments is, some may argue that, or the advocates for the other side, or the advocates for Burns may say that he has already been rehabilitated and there is thus no need for further punishment. I do not want you to argue the other side's position and then respond to it. I just want you to give your position. Start off, instead of saying the other side may argue, start off that same paragraph by saying something like, you should not rely on rehabilitation in making your decision, right? Then you're arguing what you want to argue. You're arguing affirmatively, and then say why rehabilitation should not be a major factor in the decision, or it should be outweighed by retribution. So avoid arguing defensively, right? These are all very common things. and as you get them yours back, you'll see if you did them, but those were some of the observations so far. Okay? I'll see you.